Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Good morning, Chattanooga. This is Attorney Clay Whitaker, and I'm here from the law firm of Williams, Ashley, and Stanley. Talking today on the show that we do weekly is Legal Bytes, bringing you the current legal issues that touch the lives of the citizens of Chattanooga and the Tennessee Valley. And so today we're going to talk a little bit about some of the issues related to the topic of consumer protection. And just the brief issues related to that. Consumer protection is an idea, a concept that came about in the last century, the 20th century, that believes that and is the basis for the idea that the laws should reflect that there should be fairness in consumer transactions and related to particularly to the consumer. And so Tennessee has a number of acts that have been put forth by the legislature to protect the consumer, the average person, against the unfair practices that some folks in the commercial trades would employ upon you. For instance, casual review of the law, and this is both state and federal. There are approximately 50 statutes that have some aspect or some way that protects the consumer. And a good example of that today we're going to talk about is the Tennessee Consumer Protection Act, and some of the other acts that you might be familiar with, or topics that you might be familiar with, relate to, for instance, the purchase of memberships at gymnasiums. There are provisions that allow sort of a 3-day window that allows you some time to consider your purchase and make sure that it's one that you believe is an appropriate purchase, and then you have time to rescind. There's also the same sort of concept that's applied in regards to the purchase of vehicles and other issues, so-called Reg Z, which allows the purchaser to rescind the purchase after a period of time. Finally, there are some additional laws that relate to the topic of healthcare and to construction. So we're going to touch on a little of those things so that anyone who's interested may call in. Our number here at Nooga Radio is 800-8949, of course, area code 423. We're 92.7 FM. This is the show Legal Bytes. I'm your host, Clay Whitaker. Be joined later by one of the other attorneys in our firm to discuss these topics also. So first, let's talk a little bit about the Tennessee Consumer Protection Act. This act was, of course, enacted by our legislature back last century, and the idea behind it is to prevent the commercial transactions that many times people have seen played upon them in the past that have resulted in what we call an unfair or deceptive trade practice. The statute actually goes into quite a bit of detail about what those kinds of particular trade unfair practices are. And they would be things like if you're passing off goods or services that are false. So you claim something about one of the commercial tradesperson passes off the goods of another as something that is not true. You say something that's not true about them. Or you cause the likelihood of confusion or misunderstanding as to the source or sponsorship or the approval, certification of goods and services. So the idea behind these kinds of things is that the person that's selling the service or the goods represents them to be one thing, and it turns out when you look into it, it's really something different. And so when you get to purchase the item, you are led to a state of confusion as a result of the way that the property or the particular service or good is represented by the person selling it or providing that service. One of the things that you might have heard, a name that you might have used in the past, is called the bait and switch. So basically you're advertised for a particular item, and when you get to the place where you're trying to purchase it, it turns out it's something else. That bait and switch is an unfair and deceptive trade practice, and the Tennessee legislature has acted to allow the way for for the law to interdict that. Now, there's two ways that happens. There are essentially, under the Tennessee statute, there are 33 different types of unfair recognized trade practices. And there is also a catch-all phrase. However, you've got to specify specifically one of the particular acts that the statute has mentioned as an unfair, deceptive trade practice in order to be able to bring your action. The law allows for the Attorney General for the state of Tennessee to bring an action against an individual who is representing a good or service and also a particular industry. So a good example might be if you were involved in purchasing something as frequently done with folks if you're trying to buy a timeshare, and the timeshare represents a vacation rental, and that rental is represented to be certain sort of an item, and by the time that you get to the purchase of it, it turns out it's not exactly what's been represented. The law allows for the Tennessee Attorney General to take on that whole industry and to make changes to make sure that those particular things that were offered for sale are changed. You can't do that. They also have penalties, attorney's fees, and costs that you might get. Similarly, civil attorneys can bring actions on behalf of individual clients, plaintiffs, to be able to make a claim against those particular offenders of the unfair and deceptive trade practice. And as part of that, you have attorney fees and court costs. They can be treble damages, punitive damages in essence, as authorized by the Tennessee statute. So we've been joined now by our oft-time and very apt legal expert, Trevor Ashley, who's going to also help us today talk about the topic of Tennessee consumer protection and the various types of consumer protection acts. So, Trevor, I went ahead and discussed certain things to introduce the topic to the ladies and gentlemen that are listening today, and basically told them that we've got essentially a little more than 50 different types of consumer protection statutes that are applicable here. Either they're state statutes or they are federal statutes that sort of describe the types of protections that legislatures have gotten into to protect us against the bad activities of consumer providers, trade providers, that is, in the commercial field. And one of the examples we just got through mentioning was the Tennessee Consumer Protection Act. You've had some experience with that particular act, haven't you?
I have in a couple of instances, but when I very first started practicing, Bill Dietzen, who was my father's longtime law partner, was working on a case where some individuals had purchased a car from a dealership, which had been represented to them as being a new car. And it turned out that the car, in fact, was not new. And in fact, had been a previously owned car. And of course, when you buy a new car, you expect it to be in exemplary condition and not have any defects. Well, this was a used car, a pre-owned car. And so attached to this transaction then was a Tennessee Consumer Protection Act violation where a seller of goods had represented them to be as new or a certain class. And it turns out that was a misrepresentation. So that was a good case for him to have. And I learned a little bit about the Tennessee Consumer Protection Act involving at least the sale of goods being represented as a certain condition and then not being, in fact, that condition.
Well, one of the things we had sort of mentioned in leading up to the topic, the discussion, is that this is a 20th century concept. In the past, it was sort of, the history was that it's buyer beware. So if you are involved in a transaction, some sort of commercial transaction with someone, and by doing that, you end up getting taken advantage of, that's sort of your own fault if you don't watch out for yourself. Is that right?
It was sort of a caveat emptor, right, before. And now, of course, the law in the United States generally tends to focus on protecting consumers as opposed to other countries whose acts may be focused on ensuring equality or financial equity. The law in the United States, and Tennessee particularly, focuses on protecting consumers.
Well, and so one of the things that, this goes back, this is age old, as you know, it mentions in the scriptures themselves that, the unfair scales, those that are weighted unfairly to give people less than what they actually purchased. And those types of things have been going on forever. So one of the ways that the legislature's attempted to address that, as I mentioned in the introduction, is that in the Tennessee Consumer Protection Act, it actually mentions 30 or more particular types of unfair practices that those people who may be offering goods or services for sale have engaged in, and that those are the way that you actually identify whether or not this is something that's an actionable offense that either the Attorney General for the state may be engaged in to try to stop, or that the individual attorney might do.
And there is, of course, a catch-all provision. And that used to be that they've actually amended the law now, where it used to be that section, that catch-all provision, was cited very regularly for actions that didn't fall into one of these categories. The legislature has since amended the statute and said, well, before you can have a private cause of action for this catch-all provision, you must first make demand on the Attorney General to bring an action. And then I think if the Attorney General declines, then you don't get the private cause of action.
Yeah, and so there are some modifications that have happened in the law. At one point in time, that was the sort of catch-all provision allowed us to pursue things that we believe were unfair. But, you know, the legislature did sort of describe ways in which that can be limited, and that was the provision. But you mentioned a little while ago another area I wanted to talk about today, and that is the lemon law. So you were talking about you had a lawsuit that was involved a vehicle, and it had a provision in the particular suit that was for the Tennessee Consumer Protection Act. I'm assuming there also was a claim under the lemon law in that case?
I don't think so. I think in that case it had been just a common law would have been a misrepresentation claim.
So I violated the number one rule in any questioning by a lawyer, and know the answer before you ask it.
That's correct.
Well, okay. Well, let's skip that, the fact that I asked a bad question. Let's go straight to the issue of the lemon law. So for those people who have purchased vehicles here in the state of Tennessee, we do have the protection of the so-called lemon law. And the lemon law is another consumer protection statute that deals specifically with a particular product, and that is vehicles. Is that right?
That's correct. Well, yeah, motor vehicles. It's designed, the lemon, I guess, is sort of the colloquial euphemism to describe a car that is constantly breaking down.
I don't know the history behind the term lemon, but apparently that stuck with a bad vehicle. Maybe people, the callers out there who've heard that can associate and tell us why it's called the
leaves
lemon.
A bad taste in your mouth, I suppose, like a lemon might. Or although I can say I've driven a few lemons in my day, although I'm not sure they would qualify in our quote unquote lemon law. But
well, if we have any callers who are interested in the topic of consumer protection, please give us a call. We're at 92.7 FM. This is Nooga Radio. We're Legal Bytes here. Clay Whitaker and my co-host Trevor Ashley discussing consumer protection. Phone number is 800-8949. We're also at the law firm of McComb, Williams, Ashley, and Stanley. And as a result, if you want to give us a call about some topic that we're not talking about today, be pleased to discuss it with you. And also, if you'd like to discuss those things privately in our office, give us a call, 756-6400. That is our office number. We're downtown, local lawyers, and we're here for you today discussing topics of consumer protection. So essentially, Trevor, the idea behind the lemon law is if you got a bad product and you want to bring this lawsuit, you can make the allegations under the lemon law. There are some requirements in the statute to be able to make that claim, but it ultimately would allow you to either recover, to rescind the contract, or to recover damages as a result of the bad vehicle that you've been sold.
That's correct. And this is, I guess, one of the most important limitations is there's a very strictly interpreted 1-year statute of limitations in the case of the lemon law, from the period where the motor vehicle was actually delivered to the consumer.
So it can really be a sour deal if it's over 365 days.
That's correct.
Maybe that's what the lemon is all about.
So, yeah, maybe so.
Okay. Well, so in either case, that's another example of the kind of statute that we're looking at here. But there's some more that we need to talk about. And I think some of the more common ones, one of the ones that I think is something that people happen into often, is the purchase of contracts in relationships to health clubs. So our statute allows us a time period in which to rescind that agreement. So if you make a contract, and we're talking about now, let's just be clear, with health clubs and certain of the things we're going to discuss in this show, juveniles may be involved in actually participating or using the service, but you got to remember juveniles cannot make contracts. So we're really talking about adults that seek the services or membership in a health club. If you do that, and it turns out that after 48 hours, you decided, I'm probably not going to get off the couch. You're not going to exercise. Not a good idea for me to waste my money on this very expensive membership, and I want to rescind it. You have the opportunity to do so. Trevor, what's the time frame on that's 3 days? So you got 3 days to do it.
Well, 48 hours would be, I guess, two days.
So if you got if it's a 3-day time period, then you've got that additional time that you've got to be able to rescind that agreement. But that's something also that protects sort of the buyer's remorse that people have as a result of being involved in purchasing things they really don't need or don't want.
And and there's a lot of consumer protection provisions that provide for essentially right of rescission, no questions asked, and that 48 hour period. I know, for example, when we purchased our home alarm system, there was I think it was a 36 hour or 48 hour time provision where you could essentially just walk away without any financial liability.
Well, and so those are good things. And there's another one that qualifies with that sort of 3-day rescission period. And that seems to be the statutory sort of measure that the legislature has used to determine whether or not if you decide you want to keep it longer than 3 days, it's yours. If you decide you want to do it less than 3 days, then you can get rid of it. Another one might be the Buyers Club. So for those people who are members of Sam's or might be members of some other Buyers Club like Costco or some other club, you have 3 days to get rid of that contract after you've entered into it. The statute actually says that you've got till 12 midnight of the third business day to attain cancellation. It must be done in writing. Like most of these cancellations, you can't simply call up. You've got to do it in writing, and that usually is by the delivery in some fashion, whether it's by hand delivering it, mailing it to them, faxing it to them. These days, you may be able to email it. I'm not sure what the status of transmittal by electronic transmission might be in terms of our legal jurisprudence. At this point, we have a lot of things like this that we really don't know the answer to. But the idea then is simply, and the statute simply says you've got to transmit it by legal writing.
And this is interesting. It's 3 business days. So that could be up to probably 5 calendar days if you signed up on a Friday. So then you wouldn't count Saturday or Sunday as far as business days go, and then Monday or Tuesday. So that would give you actually 5 days.
Well, that's why you're here, Trevor, because that's a tricky legal answer, and I like the way you're thinking. So.
That's right. Well, we're always trying to parse the language here in these statutes.
Well, so, ladies and gentlemen who might be listening to us, those of you who are consumers and feel at some time in the past you've been defrauded in either purchasing some good or service, please give us a call, 800-8949. We're at 92.7 FM. We'd love to talk to you about these issues. Surely there are people out there who have had a bad experience resulting in which they felt like they've been unfairly taken advantage of in the purchase of a good or service. And so we've got a few more things that we want to talk about. I think in the second half, Trevor, we might get into some of these ideas that we've discussed in our legal practice related to construction. You've got a couple of cases where you've had some experience with construction law, and those folks who may have either built a home or have purchased a home, and as a result of that, may have touched on one of the areas where consumer protection gives a little redress to the homeowner or the purchaser.
Well, there is, and the way I guess we'll get to it the next half hour, but the law is written very broadly. Now, the way the courts have construed and interpreted the law, it doesn't always come out the way you think it might on first reading, but there is certainly some wiggle room in there on all sides to present different theories of the case. So that's one thing that's important, I think, to remind folks is that whether you're the consumer in the transaction or whether you're the merchant in one of these transactions, it's important for you to seek legal advice. And of course, we would be able, as trained attorneys, to see these things from all sides and represent, either the consumer or the merchant in the case of, any one of these types of violations, as far as explaining what the rights and responsibilities are and what the potential remedies and ultimate liability might be.
Well, that's well said, Trevor. One of the things I want to mention before we break in this half, because I think the second half, let's focus a little bit more on real estate and some of the problems with either rental transactions with construction law. But many times people are involved in these rental purchase agreements. And so Tennessee actually has a protection act that's set up that requires some disclosures. If you're going to say purchase Used to be a lot of rental companies. I'm not sure. I don't see that many anymore. But if you want to purchase a television or a sofa or some other piece of furniture as part of a rental agreement, there are requirements in the law that basically set out the terms of the agreement. The statute requires a number of disclosures to be made. And you can see that this is an area where consumers have been taken advantage of as a result of trying to purchase things, and then ultimately the ownership of that purchase gets strung out over time. The payments get strung out. You actually pay more than it's really worth, and you pay more than what you agreed to.
And then you have, when it's a leasing situation like that, it's not like where you've purchased something and collateralized the item, and so then a creditor has a security interest and a future contingent possessory interest. With the lease purchase, the lessor can come in essentially and repossess the leased item with really no notice at all to the lessee. And so it's these things are designed to put some protections in place for the consumers, because they really could, like you said, ultimately spend more than what the item was worth, obtain absolutely no equity in the item, and then have the lessor repossess it essentially without having to provide notice or opportunity to cure.
And that's unfair. So one of the things we wanted to mention is that there are some prohibited terms in the agreement. Now, many times today with the way that things are, and there's sort of a homogeneity, things are all the same as it were in these kinds of businesses, but there are still some groups that do things that are inappropriate. Prohibited terms in these agreements, one would be requiring the confession of a judgment, and you can see why that would be unfair. Saying that a judgment in the amount of blank would be required. That takes away the judge's opportunity, if a case has actually had to be filed by the rental company, for the court to look at the fairness, the overall equity of the agreement and what the terms of it were, and then how that agreement's been paid out, and how the parties' behavior in both sides has been conducted during the terms of the lease. You can also see that there's a requirement that you cannot have a garnishment of wages agreement in the terms of the document that you sign. Also, you can't have the granting of authorization to the lessor or a person acting on their behalf to enter lawfully on the consumer's premises to commit a breach of the peace to repossess the property.
And that's exactly the situation earlier, where without this act, we're just asserting a right to reclaim their personal property.
And that's unfair. You can't have people with the authority to just walk into your home, and obviously it's unsafe for a number of reasons.
Absolutely so, yes.
And so you can't also have the requirement that a consumer waive any defenses, counterclaims, or rights of action against the lessor. Many times, these sort of agreements are one-sided, and we can talk a little bit about that in the landlord-tenant law that we'll have in just a second half. But finally, there's the requirement of purchasing insurance from the lessor to cover the merchandise. This is obviously a way for the lessor to take advantage of someone and jack up the price for insurance when really not required.
That's correct. And a lot of times, particularly in these lease purchase agreements, the lessee/purchaser are less sophisticated perhaps than consumers and other transactions. So the law is designed to give them extra protection.
And that's well said, Trevor. We're almost to the end of the break. We're here, Nooga Radio, 92.7 FM, AM 1240, 800-8949. If you want to give us a call in the second half, we're going to talk about construction law, the Landlord-Tenant Act, and how we protect the consumers of the Chattanooga, Tennessee Valley. This is Clay Whitaker and my colleague, Trevor Ashley, here on behalf of McCoon, Williams, Ashley, and Stanley. The show is Legal Bytes. We'll see you in the second half.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM. 3, 2, 1. Chattanooga Radio, AM 1240 and 92.7 FM's news now.
Potential massacre averted at a Republican baseball practice game. Republican Chuck Fleischman was bloodied in the scuffle to escape gunfire. Majority Whip Steve Scalise shot in the hip. The man next to him, also a representative, a former Army medic, created a tourniquet out of a makeshift belt. Fleischman telling the press the scene looked like a nightmare. The shooter reportedly in custody. A car chase ends in a car crash in Campbell Street after the police say a man spotted a car which he believed was a car that was stolen from his grandmother. He gave chase. The stolen blue Ford Focus turned a corner too quickly and smashed into another car driven by a 66-year-old woman. She had to be extricated and treated Eyewitnesses say the accused thief escaped on foot, visibly injured. Short-term vacation rentals hit yet another roadblock in Chattanooga, this time as concerned parents and teachers voiced concerns about potential predators preying on children from these short-term vacation rentals. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Expect partly cloudy, hot, and humid weather out there through your afternoon. A few isolated showers and storms, though, will pop up. Highs near 90 tonight. Any showers diminishing. Muggy lows near 70. For Thursday, a few more scattered afternoon showers and storms will roll in. Highs upper 80s near 90 again Friday. Tired of the pressures and hassles of car shopping? Come see why more people are making the short drive to Jackson Chevrolet Buick GMC in Lafayette or online at jacksongm.com. That's Jackson Chevy Buick GMC in Lafayette. And I'm Source 12 Chief Meteorologist Patrick Hoare on Nooga Radio AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams & Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza. And in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson or take home your steaming deep dish square pizza, you'll love Jet's. They use only the best ingredients in a family recipe. Also try the cheesy bread, wings, chicken, or bread with bacon, antipasta, or Greek salad. Jet's Pizza at Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. jetspizza.com. That's jetspizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike.
Life is short. Eat better pizza.
Let's get Jets. Hi, this is Nadia behind the green door. You've had ice cream and you've had shaved ice, but have you had snow cream? It is amazing. It's light, airy, fruity snowflakes melting on your tongue. You need to come and see us. Highway 58, green door next to Hardee's.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree? Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Hey, Chattanooga, we're back. This is Legal Bytes. I'm your host, Clay Whitaker. Also here is my colleague, Trevor Atchell. We're on Nooga Radio, 92.7 FM, AM 1240. It's 800-8949 if you want to call in. Today we're talking about consumer protection. First half, we talked about more of the common things you might run across in relationship to consumer protection law. That is violations of the unfair trade practices under the Tennessee Consumer Protection Act. Those issues related to sort of buyer's remorse when you purchase something you really don't want, related to buyer's clubs and health clubs. We also mentioned a little bit about the disclaimers that are required in regards to a personal property that's purchased under a rental agreement and the prohibitions that the Tennessee statute has regarding the things that might be placed in an agreement that are unfair to the consumer. So,
and Clay, before we continue, I just want to point out to anybody
got a little roll there, Trevor. Sorry.
Who's watching on the internet that we've adjusted the camera, so Clayton here is no longer hogging the camera view over there. And we got both of us now on camera. So
thanks for doing that, Trevor. Appreciate you pointing out. I'm always I want to make sure that the camera's equally applied to both those.
The viewing audience now can see everything that's going on.
There really is another person here. It's not just you. So I wasn't doing the two voices.
So. We didn't know. You might perhaps were a ventriloquist. We don't know.
Well, okay. So this second half, we want to talk about some other things that people run into in their lives that are important. It's important, and Trevor and I feel strongly about this. Those people in our society who are most likely to be taken advantage of need the protection of the law. That's the whole purpose of the law. Local law is good. The law that allows you to be able to watch out for those things in society that have long plagued us, such as the unfair scale that weighted on behalf of the seller of the good or someone who provides a service that's shoddy. So we need to have the protection the law has, and that's concerted effort for all of us. You agree with that, don't you, Trevor?
I certainly do. And I will say people sometimes raise the question about some of these laws about whether this infringes on sort of the capitalistic nature of our society, and worry perhaps that, these types of protections are infringing upon one's free exercise in business negotiations and things. But you're absolutely right, though. These are designed to protect folks who are the most vulnerable in our society. And they're certainly narrowly tailored to accomplish that objective. And so I think they serve a compelling state purpose, and certainly think that they're constitutional and need to be here, need to be on the statutes.
So liberty's great. We're all in favor of liberty, but we want to make sure that those who use their liberty don't do it in a way that is, and the law has some morality components to it, that is immoral, unfair, that doesn't look out for those people, like you say, who are most vulnerable. So let's talk a little bit about an area where that may occur. One of the things that we frequently find are people who have signed leases, and the leases are really one-sided and very difficult for the person, very onerous for the person who is the lessee. The lessor has the opportunity, because they're the person who actually has the property, to create a lease that's not fair. Do you agree with that?
We do. And just for the listeners, lessee is synonymous with tenant, in case somebody's wondering who the parties are, and lessor would, of course, be the landlord.
Yeah, and so historically, the reason that Tennessee enacted the Landlord-Tenant Act is to address these sort of problems that arise in this agreement, this relationship.
That's right, and this is sort of, I think, probably peculiar to Tennessee. Some of our statutes, like this one, are designed only to apply to counties with a certain population size.
Well, and so that would be Memphis, Shelby County, Davidson County, Hamilton County, and Metro County in Knoxville.
Correct. And so, for example, if you're in Pikeville, if you're listening to us and you're in Pikeville, if you're listening to us and you're in Bledsoe County or something, this act probably doesn't apply to you.
So you've just got common law at that point.
Correct.
And so when you're dealing with common law, you're talking about whether or not the contract in and of itself, certainly whether it was formed. First, you have to deal with the formation of the contract, and then whether the terms are fair. Basically, that's what's going to happen if you end up going before probably a general sessions court in some county that's not one of the major counties. The court's going to look at whether or not the formation of the contract occurred, and if it did, if there's a meeting of the minds, and then whether the terms are fair. Does that agree? You agree with that, Trevor?
Yes, although in those are more remote counties, there's the landlord's probably going to be able to insert more pro-landlord provisions than would be allowed under the Uniform Landlord and Tenant Act.
I would agree with that. So let's talk a little bit about this act. So the act deals, as you've already indicated, with the four major counties, and it deals with the particular relationship between a landlord and a tenant. So the bottom line then is that when you are in one of those counties and you sign a lease, that the lessor has to have a lease that complies with the terms of the Landlord-Tenant Act. You agree with that?
Undoubtedly, yes. And so in the absence of a written lease, the terms of the Landlord-Tenant Act apply. And if you have a written lease, the written lease controls, unless it conflicts with the provisions of the act, in which case the provisions of the act supersede the provisions of a written lease.
So let's talk about one of the areas where you tend to have problems. The deposit might be one of them. So in the act, there's a requirement that the landlord place the deposit that someone pays in either response to the unwritten lease or the written terms of the lease, and they're supposed to place it in a separate account. Why is that?
Well, that's correct. It's essentially because the landlord's holding that security deposit in trust. It's not money that the landlord has earned. It's money that the landlord is depositing for in the event the tenant breaches the lease or the tenant damages the premises in some way. And so a security deposit would be used at the termination of the lease, either for payment of back rent or to go toward the repair costs for any damage caused by the tenant. So what the law essentially is providing there, without expressly stating it, is that the landlord is holding this money in trust and therefore shouldn't put it in its own, commingle it with its own funds, its own account, but needs to hold it in a separate account where it can be identified and set aside from the landlord's own funds.
So many times you'll find that people leave a leased property and they don't do what's called a checkout. So they just take off and leave. If they don't do a checkout, usually the terms of the lease has something in it that requires the property be returned to the condition in which it was released, which it was leased, and or to clean it. And so what ends up happening is that landlord will take that money, hire someone to clean the property, and deduct from the deposit the amount that required the repair or the cleaning of the property. You agree?
That's correct. And the law provides a procedure for how this is supposed to work. So a lot of times tenants, like you're saying, will just, what you're describing almost as an abandonment of the leased premises. The landlord is required to send a list of repairs that are required or expenses that can be required to the tenant, but the landlord can only send that to an address he knows. And so very often the tenant's last known address is the address where they have been residing. So the landlord sends that notice to that address and the tenant never receives it because they've essentially just abandoned the premises without leaving a forwarding address. And so a lot of times people actually I presume they think that they're taking action that's in their best interests by just abandoning and not providing information to the landlord, but actually can work to their detriment in these circumstances where they otherwise might be entitled to contest some of what the landlord is saying they caused damage to the property.
One of the other areas I find that's a problem many times, Trevor, is the term of the lease. And I've had a number of young people call me, people who have just started becoming active in their lives, taking responsibility for things. And when I say I'm talking people in their 20s, and they've just started using their ability to contract. So one of the things that'll happen is they'll make a contract for a lease. They won't necessarily understand two things, one being the term notice, what notice means, and the second being the term of the lease. So you'll find that the lease requires notice to be given to the landlord prior to the vacating of the property. If you don't follow the terms of the lease that says you have to give that notice, you owe additional rent that's outside of the term of the lease, the term of the lease being the amount of time that you agreed originally to lease the property. Have you ever seen that happen?
Oh, countless times. So normally what happens is, so let's say a typical residential lease is a 6 month or a year term. Let's go with the year term. So you've agreed to pay, the tenants agreed to lease these premises and pay the landlord monthly rent and blank amount of dollars for a term of 12 months. So every month, on the first day of the month, the tenant's going to pay the landlord money. Well, sometimes the tenant thinks at the end of the year, the occupancy agreement just is done. It just expires. That's not the case. In almost every circumstance, the written lease contains a provision, a carryover term, that says in the event the lessee continues to occupy the property at the end of the term, then the terms of the lease continue, but the occupancy agreement now is a month to month. So in order for the tenant to vacate and be in compliance with the terms of the lease, they have to provide normally 30 days written notice in advance of the date they intend to terminate the rental agreement.
For our listeners out there, that's just a good way to lose money. You agree with that?
Yeah, absolutely. Yes.
All right. So here we are. We are the guardians of your interest here in the Chattanooga, Tennessee Valley. Clay Whitaker and Trevor Ashley on the legal show, Legal Bytes, on Nooga Radio, 92.7 FM, AM 1240. We're from the law firm of McCoon, Williams, Ashley, and Stanley. Our phone number there is 756-6400. You can call us about any legal issues. We'd love to talk with you. Also, if you have any questions today, while we're here on Legal Bytes, discussing the hot topics in legal issues that face you during your life, you can do that at that number, 800-8949. Trevor and I have been talking about the issues of consumer protection, and particularly in this last few minutes, we've discussed the issues of the Landlord-Tenant Act that apply here in Hamilton County, and then sort of common law issues that might apply in other areas.
And Clay, let me interject here before we move on to anything else. Under our Uniform Act, which I think where the teeth of the matter come in, is where a tenant is renting a place and the landlord is not doing his job maintaining the property.
What happens then, Trevor?
So in that case, then the tenant has the option to send written notice to the landlord and say, landlord, this house is not up to code. These things need to be fixed. And then the landlord has an affirmative duty to come in and make those repairs. And if the landlord doesn't, the tenant has options. The tenant can say, I'm terminating the lease and leaving. And that is without any further financial liability. And you would get return of your security deposit, unless, of course, you had left holes in the wall or something. But assuming the premises was in the same condition as when you acquired an interest there, you'd get your security deposit back. So that's a way for you to have some protection as far as maintaining the condition of the residential structure. And then the tenant can also, if it's something that affects the health and safety or welfare of the tenant has a right to make demand on the landlord to make the repairs. And if the landlord refuses, the tenant can either go out and make the repairs himself and then deduct whatever he paid from the monthly rent, or he can say, landlord, this is not habitable. It's not safe for me to be here. I'm going to go out and secure alternative rental space. And during that time, the landlord cannot terminate that lease, and the tenant can try to recover whatever the additional costs for the new rental are against the landlord. So there's some real teeth in there to protect tenants in these circumstances where a landlord is just really maintaining a bare minimum type residential structure, kind of a slumlord type picture in your head there of what the type tenant might have, making demand on the landlord to make these types of repairs.
Well, and it goes again, Trevor. The squeaky wheel gets the grease. We'll lay out all the truisms. Sitting on your rights is not a good idea. Knowledge is power, and it's always important to realize that lawyers can save you some money. So when you get into the set of circumstances, remaining silent is not a good idea, except if it's a criminal case. Then that's a whole nother rule. But otherwise, you need to be vocal. You need to talk about your situation with your landlord. Don't act like the landlord knows about it. There are provisions in every lease almost that require you to give notice to the landlord of any problems. And the reason is because the landlord-tenant act says it's a good idea to do it. And that allows the landlord to act. If you don't give him notice, he can't act. So it's always important to, number one, follow the terms of your lease. Number two, if you don't understand them, call your local lawyer. Someone like Trevor Ashley or Clay Whitaker here, we're the guardians here in this area, Tennessee Valley, Chattanooga, Tennessee, for your consumer rights. We'd love to help you out. Our number here, 800-8949. Give us a call on Nooga Radio. You can call us at our office also, McCoon Williams, Ashley, and Stanley, 756-6400. We'll talk to you anytime about any questions.
And Clay, let me give you this is by way of illustration, and this is kind of off topic a little bit, but talking about, are these consumer protection provisions an infringement on liberty, entering into contracts freely? And this is anecdotal, but one of my wife's cousins works for GE, and he was sort of some mid-level executive, and he was working with GE in their acquisition of Alstom, and that was a French company. And the process got all gummed up because the French government would not approve the transaction. And when we talked about that, I naturally assumed that France's interest would be on consumer protection interests, as the United States typically is, if the Department of Justice tries to intervene. And he says, no, France's interest is protecting France. And so it's just a very different, our protections here are narrowly tailored to protect these specific instances. And sometimes you hear people compare it to socialism. And I really do think if we had just an open and honest debate about that you would see that these are very narrowly tailored to accomplish a compelling state interest.
Well, that's a good point, Trevor, and I really appreciate you bringing that out. One thing people don't consider is the function of attorneys in this whole process. Many times these laws are the result of lawsuits that have been brought by attorneys who have pursued the rights of the individual plaintiff who's been taken advantage of by someone in the commercial field. As a result of that particular action by an attorney, the legislature's gotten to work and has done something to look out for the little man. So that's not socialism. That's looking out for your neighbor. That's certainly part of our requirement to be able to do that. And I think it's part of the legal community's commitment to bringing justice even to those who are least likely to receive it because they're not able to afford it. That's what attorneys do. That's what we're committed to. We're here to do that for you. Give us a call at 949. Let's talk a little bit while we still have some time remaining, Trevor, about the issues related to Truth in Construction Act and the requirements that contractors be licensed here in the state of Tennessee. You've got a little familiarity with that, so do I. So we've got a case. Let's just lay it out. Let's say that someone's building a home and they put out the request for someone to give a bid on a particular contract and what it's going to cost to build that. They get in touch with some folks who hold themselves out to be contractors. What's the first thing you need to do?
Well, if you're the property owner and you're wanting someone to come and work on your property, you need to see a copy of their license.
You need to make sure they've got a contractor's license that's issued by the state of Tennessee. And also one of the things would be to make sure they're insured.
Oh, absolutely. Yes. And that includes liability insurance as well as workers' comp insurance and all those other types of insurance that they're required to maintain.
And because you've got a license as a contractor, it didn't used to be that way, but now it is required that contractors be licensed. And because they are, that gives the consumer some protection. Kind of tell us a little bit about what it does for us.
Well, obviously the underlying purpose there is the legislature determined that people working in the construction industry need to have some requisite knowledge of construction practices and how to properly construct. Particularly, we're concerned about residential structures. And the licensing is, well, it's a way for the state to say they've passed these examinations, and the state will license you now to work in this area, having demonstrated the requisite basic knowledge required to work in this field.
It's a floor, not a ceiling. You agree with that?
Oh, absolutely, yes. It's the baseline.
So obviously, anyone who is interested in building their own home or having construction done on their home needs to do their investigation. This certainly is not a way that you can rubber stamp the qualifications of an individual contractor, but it does say that at least Tennessee has recognized their basic requirements have been passed.
And let's also talk about this. In Tennessee, a property owner can construct a residence on his own property without being licensed if he intends to reside there. Now, if he's entering into it, however, for purposes of resale, now our focus shifts because we're going from a personal use to a more commercial use. And so then you start getting into, well, now we have a prospective consumer. And so then you have to wonder, and the law does provide in that instance, then the property owner constructing a house on his own property for purposes of resale now is focusing more in a commercial capacity as opposed to an individual capacity.
That's not to say if you build something on your own home that you can just put anything up that you want. It is still required that you have to build in compliance with the building code, and you're going to have function at least with that rudimentary idea at heart of whatever you build, that you've got to have anyone from either the county, if you're in the county, or if you're in the city, the building examiners and building construction folks are going to come in and take a look at what
Absolutely
you built.
Right. And it's all, most municipalities have adopted one of the building codes, and we have to look to see what Chattanooga's adopted. And, East Ridge, for example, has adopted a different code. There to see exactly what the code provides and build according to the building code.
So that gives you some protection. Before we run out of time here, Trevor, I do want to go on to the Truth in Construction Act. I think that is an important thing. Past this issue, and you started building, you acting as what we call a general contractor. That is, that his responsibility is to make sure that the total project is built and that he's going to pay his subcontractors. So those trades that might be employed on his behalf to build the things that need to be built as part of the whole project. That general contractor has some obligations in the Truth in Construction Act. And basically, to sum it up, they're required to make sure and have disclosures that are filed that say that they've paid the money that's required to the subcontractor, so the homeowner doesn't end up owing money to a subcontractor. Is that a short way to put it?
Absolutely correct, because people that provide that type of work in construction industry are entitled statutorily to what's called a mechanic's lien or a materialman's lien. And the contractor, essentially, they're saying that these folks have been paid and therefore can't come back and record any type of lien on the property.
You got a 1-year statute of limitations that allows the materialman's lien to remain in place. Otherwise, it's taken off. There's also penalties for failing to comply with the act. So this is Clay Whitaker and Trevor Ashley for Legal Bytes. We're on Nooga Radio 92.7 FM. It's been our pleasure to talk with you today. We're here every Wednesday to discuss these legal topics that come up in your life. Give us a call at our office, 756-6400. Thanks.
Yeah.